In this session, we will discuss the provisions in Indian Evidence Act regarding statements made under special circumstances. Under the relevancy chapter, that is within the provisions of section 6 to 55, a fact becomes relevant. If any fact which falls in any of the provisions of section in between the section 6 to 55, then that becomes relevant. Here, the statements made under special circumstances are relevant as per the provisions of section 34 to 39. What it says? Here, some statements are made by a person under special circumstances. What are the special circumstances? That has been provided in the Act. In this section, the first section is section 34. So, for proper understanding of this section, it will be proper if you will keep the Bare Act with you. Law is such a vast subject, all provisions cannot be remembered. You have to find out the laws. Laws are there in the law books. But how far we understand the law or a particular section, then reference of a particular section is always necessary to understand that provision. Law is never taught in lecture method, because if law is taught in lecture method, it may be better for you to appreciate or to hear it, but you cannot remember, you cannot understand the fundamentals of law. So that's why law should be read by word. How we interpret the law by word by word, then you can understand the law properly. For that, you should keep the Bare Act with you. What section 34 says? What says? Entries in books of account when relevant. So it is a statement made under the special circumstances. That is, when an account is maintained in respect of some transaction, entries are made, then that entry in a book or in account book, that becomes relevant. What it says? Entries in books of account, a book containing the accounts of different transactions, including those maintained in an electronic form. Previously, this electronic form was not there. By way of amendment, then it was included in this section. Entries in books of account, including those maintained in an electronic form, regularly kept in the course of business. You should be very careful to understand know the term regularly kept in the course of business. That entry must have been made in the course of business, which is performed regularly, are relevant. So, when the entries in books of accounts are relevant, the entries made in books of accounts or electronic records, if those entries are made in the regular course of business, regularly kept, that book is kept, that the accounts is kept in the regular course of business. If entry is made in a book of account or in an electronic form nowadays are for Information Technology Act 2000, that amendment was required, and accordingly amendment was made in section 34 of the Evidence Act. So entries kept in books of accounts, regularly kept in the course of business, are relevant whenever they refer to a matter into which court has to inquire. To what extent? Whenever that entry is with reference to a matter into which court has to inquire. But such statements shall not alone be sufficient evidence to charge any person with liability. What are the books? What are the account books in which accounts are kept? The common example is bank account. Where in bank, in the regular course of business, account is being maintained by the bank officials in every day-to-day basis. So whenever there is an entry in a bank account, either manually or in electronic forms now, computerized form, electronic forms, an entry is made by a bank officer, which is in the book of account, which is kept in the regular course of business. Regular course of business is very important. Suppose a particular account is maintained not in regular, in casual manner. So that entry will not be relevant. For making an entry relevant in a book of account, that book of account must have been maintained in the regular course of business. Or in electronic form, if it is maintained in the regular course of business, then that becomes relevant. But such statement shall not alone be sufficient evidence to charge any person with liability. This section consists of two parts. The first part is in affirmative and the second part is in negative. What negative? That such entry is itself alone will not be sufficient to make a person liable. Some other evidence supporting evidence is required to make a person liable basing on that entry. So section 34 will be applicable when there is an entry in a books of accounts or in a which is maintained in the regular course of business, or in a electronic form, account maintained in electronic form in the regular course of business, are relevant to what extent? With reference to the matter into which court has to inquire. Suppose whether a particular person has borrowed a particular amount, or how much amount is due in respect to a particular loan of a particular bank. In such case, the ledger account of the bank, which is maintained by the bank in the regular course of its business, is relevant. But that entry is not sufficient, alone will not be sufficient to make a person liable. For an example, say for a particular bank filed a suit for realization of 20 lakh rupees from a particular borrower, including that and including interest. So the bank simply produced the ledger account to show that a particular borrower is liable to a certain amount. But if that ledger was being maintained in regular course of business, but that entry alone will not be sufficient to make the person liable, but some other evidence is required, corroborating evidence is required, some other evidence, supporting evidence is also required to make a person liable. In such case, usually bank examines an officer who says that somebody had borrowed some money and he was aware of the fact. In addition to the bank account, ledger account, an officer of the bank is also examined in court to make a person liable. So what this section provides, that entries in a book of account, including those maintained in electronic forms, are relevant when those accounts are maintained in the regular course of business. But you must keep in mind that entry will not be sufficient to make alone will not be sufficient to make a person liable for that entry, for the disputed matter, or for the amount which is mentioned in that account. So illustration will make you clear. A sues B for Rs 1000 and shows entries in his account books showing B to be indebted to him to this amount. The entries are relevant but are not sufficient without other evidence to prove the debt. This book of account not only bank, suppose somebody is purchasing certain goods or certain cloth on credit basis, the shopkeeper is maintaining a book of account. If that book of account is maintained in the regular course of business but not in casual manner, then that entry becomes relevant with reference to the amount which is due against a particular person. But that entry alone will not be sufficient to make a person liable. Some other evidence in addition to that entry is required to prove the liability of a person. Now this is section 34. Now coming to the section 35, this is another section which says that entry, that what is in the statements made under special circumstances. This is another. Section 35 says, relevancy of entry in public record or an electronic record made in performance of duty. Many public officers, they maintain various registers, various documents while performing their duty. If such a register is maintained, then that is relevant to prove the fact which is in issue or any relevant facts. What it says? All entry in any public or other official book. This is public or official book, register or record. Entries, all entries, whatever entry is made in all official book or public book or public register or record or an electronic record, what? Stating a fact in issue or relevant fact. Entries regarding fact in issue or relevant fact. What is fact in issue? Any fact from which either by itself or in connection with other facts, the existence, non-existence of any nature, extent of any right, liability or disability is asserted or denied. From that, a fact on issue will come. Suppose A files a suit claiming 5 lakh rupees from B, saying that he had borrowed that amount. B denies. So the fact in issue in this case, whether B is liable to pay that amount of rupees 5 lakh to A, that is a fact in issue. So all entries, an entry in any public or other official, any entry made in public book or other official book, register, record, an electronic record stating a fact in issue, that is a fact in issue or relevant fact. One fact is said to be relevant if that comes within any of the provisions of relevancy chapter, that is within the provisions of section 6 to 55, that becomes relevant. So any entry which is made in any public register, then or a official book regarding the fact in issue or relevant fact and made by a public servant to make it admissible in evidence, that entry must have been made by a public officer, public servant in the discharge of his official duty or by any other person in performance of duty especially enjoined by the law of the country in which such book, register or record or an electronic record is kept is itself a relevant fact. So an entry which is made in an official register regarding the fact in issue or relevant fact, if that entry has been made by a public officer while discharging his official duty or any other person who has been required under law to make such entry, then that becomes relevant. For an example, there is an issue whether regarding the date of birth of a person. The date of birth of a person, that is an issue. That is fact in issue whether what is the date of birth of a particular person. Suppose an entry is made by the by a public officer while discharging in this government hospital, there is an entry in the birth and registers book this is the date regarding the date of birth of a particular person. Then if that has been maintained, that entry has been made by a public officer in the discharge of his official duty, then that becomes relevant. So to make this entry admissible in evidence, that entry must have been made in a public register and by a public servant while discharging his official duty. Suppose a peon who was not required to make any entry regarding the date of birth, but in absence of the person who was required to maintain that register, he had made an entry. So in such case that will not be relevant, because that must have been made by a public servant who was required to perform that duty. Sometimes in some offices, private persons are engaged to help some public servant. If he makes an entry, then if he has entered, then that entry will not be admissible as in evidence as per the provisions of section 35. A private person is helping a clerk or is helping a particular Shirastadar or particular head clerk in his work, but in his absence he makes an entry. So in such case that entry will not be relevant, because here he was not required under the law of the country to perform that duty. Only the officer, public officer who was required to perform that duty and to make such entry, if he has made that entry in a official book or public register regarding the fact in issue or relevant fact, then such entry becomes relevant as per the provisions of section 35 of the Evidence Act. It is one of the provisions that is statement made under special circumstances. So in this case, three requirements must be satisfied. The document must be in the nature of entry in any public or other official book, register or record. Second, it must state a fact in issue or relevant fact. The entry must be made by a public servant in the discharge of his official duty or in performance of his duties especially enjoined by law of the country. If a private person had made that entry as per the direction of a public servant who was required to make such entry, then such entry will not be admissible in evidence as per the provisions of section 35. Now coming to the provisions of section 36. What section 36 says? Relevancy of statement in maps, charts and plans. Sometimes you are aware of that in every settlement, after settlement, a map is published, and that map is offered for sale. Some map, charts, plans, some town planning maps, that is available for purchase. What is that? So what it says? There are statements of facts in issue of relevant facts made in published maps. A map has been published. Any statement of facts in issue. Facts, that must be statement, must be in relation to fact in issue or relevant facts. Made in published maps or charts generally offered for public sale. Some maps, charts, those are offered by the government for public sale. Any fact in issue or relevant fact that is stated in maps. Suppose there is a dispute regarding the boundary of a particular plot. There is a settlement map. In the settlement map, the boundary of that particular plot number has been shown in a particular way, particular measurement. So that entry is with reference to fact and issue. That to prove the dispute, whether to prove the extent of that particular plot, extent of land of that particular plot. So that becomes relevant. As per section 36, statements of facts in issue or relevant fact. That statement must be relating to fact in issue or relevant fact, where in maps, charts, plans published by the government and which is offered for public sale, or in maps or plans made under the authority of the central government. Any maps or plans which is, even if it is not offered for sale, but that is published under the authority of the central government or any state government, as to the matters usually represented, or stated in such maps, charts or plans, are themselves relevant facts. Suppose there is a town planning map. In the town planning map, particular land is in the commercial zone, a particular land is in residential zone. So that is published for information of the general public. Any map, chart or plan which is offered for sale, which contain the fact in issue, which is regarding the with reference to the fact in issue or relevant facts, that becomes relevant. Similarly, any map, chart that is usually represent or stated in the maps, charts or plans, that those maps and charts or plans published under the authority of the central government or state government are relevant. So this section speaks for itself. It is very a simple section. Statements in maps, plans or charts which are meant for public sale or which are prepared with authority of the state government or central government, which contain which is with reference to fact in issue or relevant fact, are relevant. Now coming to the provisions of section 37. What section 37 says? Relevancy of statement as to fact of public nature contained in certain acts or notifications. When the court has to form an opinion as to existence of any fact of a public nature, court is required to form an opinion regarding existence of a particular fact of a public nature. Any statement of it made in a recital contained in an act of parliament. In act of parliament, some recital is made there regarding any fact of public nature that is recital contained in the act of parliament of the United Kingdom, or in any central act, provincial act or state act, or in government notification or notification by the crown representative appearing in the official gazette or in any printed paper purporting to be the London Gazette or the government gazette of any dominion, colony or possession of His Majesty is a relevant fact. Suppose where the statement of fact concerning management of a private temple, suppose it has been mentioned in a gazette, that becomes relevant. What is it? Where the statement of facts concerning management of private temple or containing historical facts about the status of a private person was found in official gazette, then that becomes relevant as per the provisions of section 37. So here section 37 says in some acts, gazette, if any fact regarding public nature, it is any fact of public nature is mentioned, is stated, that becomes relevant. Now section 38, relevancy of statement as to any law contained in law book. What is a particular law? If any law book which has been published and under the authority of the government, that becomes relevant. When the court has to form an opinion as to a law of any country, what is the law, particular law in England? What is the particular law? What is a law on a particular matter in America? When the court has to form an opinion as to a law of any country, court has to form an opinion regarding a law of any country, any statement of such law, if any statement of such law, what contained in a book purporting to be printed or published under the authority of that government of such country. Any book, any law book purport to be printed or published under the authority of that country and to contain any such law. If that law book contains such law and any report of the ruling of the courts of such country, any report regarding ruling of any court of such country contained in a book purporting a report of such ruling is relevant. Like AIR, that is followed. Suppose All India report or a report which is published as per the authority of the country, that is admissible evidence. Similarly, when the court has to form an opinion regarding any law which is in force in a particular country, any law book which has been published or printed or as per the authority of that the government of that country, or which any law which has been published in any law report of that country, then that becomes relevant. So these are the section 34 to 38 deals the statements made under special circumstances. These are the statements made on special circumstances, and those statements are relevant. Section 39 then is a provision. How much of a statement is to be proved? How much of a statement is to be proved? Suppose a ledger account of a bank is produced. To prove the entry in it regarding the borrowing of certain amount by a particular borrower, and to prove his liability, whether the entire book is to prove. So this, you find the answer of this in section 39. What it says, if that statement is in a large statement, is in a big statement of which is a big statement or a portion of a particular book of account, so much statement which is required to make the court intelligible about the fact and issue or relevant fact, that much of statement will be proved. What it says, when any statement of which evidence is given forms part of a longer statement. A particular statement is, that is entry as per section 34, 35, 36, 37, so much of that statement forms part of a longer statement or of a conversation or part of an isolated document, or it is a part of a longer conversation or part of an isolated document, or is contained in a document which forms part of a book, that contains in a document which forms a part of book, or is contained in a part of electronic record, that statement is a portion of the electronic record, or of a connected series of letters, that statement is connected of the series of letters or papers. Evidence shall be given of so much and no more. That entire evidence, the book will not be taken into consideration. Evidence shall be given so much and no more of the statement, conversation, document, electronic record, book or series of letters or papers as the court considers necessary in the particular case to the full understanding of the nature and effect of the statement. For full understanding of the nature and effect of the statement, so much statement is which as required, that will be taken into account in evidence. That as because a particular statement forms a part of the longer statement or a part of a large book, that the entire book will not be taken into evidence. So much of statement as contained in that book or a conversation or a series of letters which the court considers that it is necessary for full understanding of the matter in dispute. That much of statement will be admissible in evidence, but of no others and of no more. This section excludes a large document which is unnecessary part. Unnecessary part will be excluded. Necessary part of the document which is necessary for full understanding of the matter in dispute, that much of entry will be taken into consideration by the court as per the provisions of section 39. Where a long statement or document is relevant to any proceeding, the court may in its discretion require the production of only so much of the statement as is necessary for full understanding of the statement in the particular case. So this is in nutshell in the provisions of section 34 to 39. We completed. It is a small chapter. That what? Statements made under special circumstances. These are the statements which are made under special circumstances. Those statements become relevant. Probably you understood. If any doubt, you may send your doubt through message. Then in the next class, we will discuss the other chapter, that is relevancy of judgments. Though it is a short time session, probably you will be clear from this discussion about the provisions of section 34 to 39. Let us conclude. Thank you all.